Thank you, Adam, and welcome to the Happy Holiday edition of Workers' Comp 202. Yes, it's that time of year, and we will be discussing in detail a level down from the introduction, the 101 thing that we do. We're going to show you some best practices workers can use and also some of the points in the system that you probably should be aware of. So let's get started. The Advocate for Injured Workers. Who is this? Well, in point of fact, this is me. And I actually manage an office of people. We are the advocates. We help workers with the more difficult and complex claims, and that does happen in this system. Technically, I am an ombudsman. What's an ombudsman? That is a title that you will see in the insurance industry, the financial services industry. Hospitals have ombudsmen. We're the person inside that you can contact, inside the organization, I mean, that you can contact and tell us about the organization. We care about the health and the sanctity of the system. My office also handles fatality claims. So if there is an on-the-job fatality or someone perishes due to employment, if you become aware of this, please let us know because we want to reach out to the surviving family and help them claim the benefit because there is a fatality benefit. And along those lines, we work with the 9/11 community. I am probably the board's liaison to the 9/11 community because that terrible situation is ongoing. So here you can see our webpage on wcb.ny.gov, where we have some resources for the 9/11 community. And we're showing you 3 different resources, 2 of which are not even administered by this board. We don't have a formal role in 2 of these, but we want you to know about them because we want you to help recover from this disaster. So on the far right, you see the World Trade Center Volunteer Fund that is run by the board. Now, just to make the point of differentiation, everyone who was paid to respond to the World Trade Center disaster, you're going to be in the regular workers' comp system. But the World Trade Center disaster is the only point in New York history where people who volunteered to help can also access a workers' comp benefit. And that's what we're talking about on the far right. In the center, that is the federal September 11 Victim Compensation Fund. So if you were impacted by those events, you should really visit the September 11 Victim Compensation Fund to see if you're eligible for compensation. And then finally, the World Trade Center health programs on the far left as you're looking. These are the health programs that are administered and run by the federal government, not the New York State, the federal. And this is free health care for people who were injured during the attacks themselves or in the aftermath afterwards. I would urge you, I'm urging you, if this is you, make sure you are enrolled in the World Trade Center health programs. All right, so now to resume the workers' comp element, we're going to begin before there's ever an incident or accident. We do this in the Workers' Comp 101. It's so important. We do it briefly in the 202, which means let's avoid an incident in the first place. How do we do that? The easiest way, the freest way, because it is free, and the simplest way is if people just talk to each other. Why don't you make a labor management safety committee in your workplace? We have some ideas on screen on how you might want to structure it. The point is people should get together and talk about either the places in the workplace that are creating incidents or could potentially create incidents. Okay, so the whole point here is if the management and the workers get together and pinpoint these areas and also think about the training that people get and who's doing the training, are they training for safety? And if you think about the equipment you use and make sure that it's used properly and is up to snuff, it's functioning as it ought to. And then finally, if you think about the procedures you use, are you doing the safest procedures possible? Well, if you get right on all those topics, you're probably going to avoid some incidents from ever happening. We have education here at the board on workers' comp that you can freely access. We are showing you the publications page of our website. Look at all of those publications just under workers. And you'll see that all of those publications are also readily available in a dozen other languages. So our publications are readily available in the languages that well over 90% of all New Yorkers speak. And then from there, we have publications devoted to employers and our annual reports, plenty of stuff. So you just go to our website, choose publications from the list at the bottom, and there you go. If you are an injured worker, this is a huge tip, a huge benefit for you. You're going to have a claim. You're going to have all of your documents in a claim folder here at the board. Because remember, the board gets a copy of all the documents related to your claim. Well, do you want to see what's in your file? If I was you, I would. So all you have to do is register for eCase. We are showing you right now how simple it is. You just put your data in these fields, and then you click submit, and you will get access to eCase, and then you can see everything that everyone else sees in your claim. It's very important because this will keep you on top of everything. Now, you might be working with an advocate who's not your attorney. The attorneys have a route to access your files, and it's well established and they all know it. But there are workers' advocates, or maybe it's your spouse who's advocating for you. And that party wishes to discuss your claim with us. That happens, it's fine. There are a lot of very knowledgeable workers' advocates out there, I can tell you with authority. I talk to them. Well, we can only speak to them about your claim if they file a form known as the 110A form. We're going to show you the form right now. You can get it from our website. This simple form is completed by the worker, and it identifies in the bottom half of the form who can see the file, who the board can discuss the details of the claim with directly. So if you want to help an injured worker, you're an advocate, you're a spouse, go ahead, workers, complete this form, file it. You have to file the original piece of paper, okay? You can't just take a photo of it and email it. You have to file the original piece of paper, and then we can discuss your claim with this other party who you wish to help you with the claim. And by the way, I did just mention photographs. Everyone, people don't know this, but I'm going to tell you now. In the year 2023, we take a lot of photos and we send them all around. Sometimes we take a photo of a piece of paper to show. Okay. The board does not, repeat, does not put photographs into case folders. It's really that simple. So if you take a photo of something and you want to get it in your case folder, it's not going in. You need to submit either a PDF of it or you need to submit the original. Okay, so now we're going to shift gears into benefits. We're going to spend a great deal of time on the indemnity benefit, and then we're going to spend time on the medical benefit, and then we have some other things to say. I hope you appreciated those first 4 tips, because those first 4 tips can make a big difference. It is possible for a payer to formally dispute a claim or controvert it. Now, when I say payer, I'm talking about the party who's actually paying the money, the self-insured employer or its administrator or the insurance company. Because you will all remember, I hope, that the board, mine and Adam's employer, the workers' comp board, we don't actually pay the money. So these payers can and do formally dispute a claim or controvert it. This is going to happen almost always at the very beginning of a claim. It's technically possible it could happen at the end, but it rarely, if ever, does. It usually happens right off the top. Okay, so here's what you need to know, workers. If the claim is formally controverted, you'll find out about it, and no benefits are going to be paid. The payers do not need to give you that indemnity benefit, the lost wage benefit, while the claim is in dispute or in controversy. So what do you do for income? Well, what you can do is you can file a short-term disability claim. So if you're eligible for workers' comp, you're probably not 100%, but probably going to be eligible for short-term disability. The easiest exception is if you work for a government, you're probably not eligible for this. But everyone else, you can file this short-term disability claim, and you will hopefully get the $170 a week. It is a maximum of $170 a week. But since it's been controverted, no money's being paid to you. There's not an assumption that you got hurt at work yet. You have to establish it to be hurt at work. You can get this money because this benefit is for injuries and illnesses off the job. And we will put your controverted claim onto the expedited calendar, and it will almost certainly be wrapped up in 90 days or less. Now, one of the decisions one of our judges might make is carrier continue payments. This is known as CCP. So if you are a worker and you've had a hearing and a judge has made the decision, carrier to continue payments at this rate per week, the carrier or the payer may not, repeat, may not change that payment or stop that payment without coming back to a judge and getting a judge to agree to it. So this is an important thing for workers to know and to understand. If you have a CCP, you're going to continue getting that payment until the conditions change. And the conditions would be maybe you went back to work. You need to tell everybody you went back to work so that the payments can stop. Or there's another hearing and a judge changes the CCP. So we're talking about indemnity payments. Your indemnity payments are based in part on your degree of disability. How disabled are you? This is such a fundamental and huge concept. Please hang in there with me. And if you are listening to me from a medical practice, I'm talking specifically to you as well, because you have to submit the degree of disability. Our system is based on medical reports. The doctors determine how injured the worker is. If there's a dispute, the board will resolve it. But we're using the medical reports. So, degree of disability. How disabled are you? It's going to be expressed as a percentage. We are showing you on screen the most common percentages. The doctor can choose any percentage, but they tend to choose 0, which means you're healthy. Congratulations. That's a good outcome. 25%, 50, 75, or 100%. 100% means you are totally disabled right now. You cannot work. Now, we made you this little chart here because there are a number of us who've been in the system a long time, and we sometimes use the old school way of describing your percentage. So you could see on the chart that sometimes it's less and less every day, but sometimes 100% is expressed as total. Total, yeah, makes sense, doesn't it? And then there are these three little terms of art. Marked equals 75. Moderate, halfway there, 50%, or mild. So we're showing you this chart so that you understand if you see these terms. Now, how are these terms used? Okay, we're going to do a little bit of math now, but I'm sure everyone's capable, and this is hugely important. Let's say we have a benefit rate. We did the calculations based on your average weekly wage, and the maximum rates come into play. So we know that your maximum benefit rate would be $1,000 a week. Okay, now we have to apply the degree of disability. This is why I'm speaking directly to the medical people on this call, because if you don't file a degree of disability, the payer can't do the equation. That means the worker's probably not getting anything. So, number one, please do the equation. Please file the degree of disability, and we'll talk about that on the next slide. But number two, here's how it goes. $1,000 is the possible maximum rate. You're a total. You're going to get 100% of that rate. That's $1,000. But 75% disabled, you're going to get 3/4 of that rate, or $750. 50%, you're getting half of that rate, $500. That's why we need the degree of disability, because if it's not filed, you're probably getting 0, and then you have to go back to the doctor and ask, would you please file my degree of disability? And then you've been without the payments for a while when you shouldn't have been. So, doctors and medical people, I'm going to tell you something specific for you, how you can help, because I know you want to, but first, we're going to do a small quiz, and I'm going to yield the floor to Adam.
So Joe and I, we want to get your opinions here. So we have a scenario on here. We're going to pull a poll up, and you can just put your answer right in the poll here. We want true or false. So we have Susan, and Susan was marked as, or I should say, was told she was 100% disabled and has been receiving $1,000 a week for the last 3 months. Susan's doctor recently said that she has healed to the point where she is now only 50% disabled. Susan has never had a workers' compensation hearing. So we want to know now, true or false, because of her new disability percentage, Susan's benefit rate will now decrease from $1,000 a week to $500 a week. And keep in mind, she was 100% temporarily disabled, and then the doctor recently said she is now 50% disabled. So again, just put your answer right in the poll that is up on your screen. A for true, B for false. We have the answers piling in. We will give you a few more seconds, but I can say right now it is about majority of folks say true. We do have, it's about 3-1, true to false. So Joe, what do we think here? Are Susan's benefits going to decrease to $500 a week?
Oh, look at that. It looks like everybody stopped responding. So yeah, it was 3-1. And when we say is going to, what we mean is it is within the realm of possibility. And this is showing you the importance of the degree of disability. Yes, the payer can certainly decrease Susan's payments from $1,000 a week down to $500, because at $1,000 a week, she was 100% disabled. But now that she's 50% disabled, the appropriate benefit is 50% of $1,000, or $500. You see the third bullet, she never had a comp hearing. Okay, we put that in there to let you know if she's never had a comp hearing, that means a judge has never made a CCP direction. No judge has said continue payments at this level. If she had a CCP, if she had had a hearing and there was a CCP in place, and now she's 50% disabled, there's probably going to be another hearing where the judge is going to be asked by the payer, can you change her benefit to $500 a week based on her degree of disability? Now, let's talk about something that can really help the workers and the doctors. Here we go. How do we get that degree of disability? Well, to my friends in the medical community, and I do mean friends, please be vigilant. Please be sure that when you file your medical reports at the point where the worker is temporarily disabled, and the doctors will know if it's temporary or permanent, okay? When the workers are temporarily disabled, they do have to go to the doctor every 90 days minimum. I mean, if you need to be treated every 2 weeks, you're going to do that. But minimum every 90 days, and the doctor has to answer the 3 important questions. We have the 3 important questions on screen. Work status, is the patient working? Causality, that means, is this condition you're treated the cause of the disability? And then finally, how disabled is this person? Degree of disability. You need to answer those questions, please, in your reports. So there are 2 ways you can do it. The easiest way, or I'm sorry, I shouldn't say easiest. One of the ways you can do it is you can simply use our medical report narrative template. There you go. This is available on the website. You can download it. You can put it into your billing software. CCP stands for Carrier Continue Payments. And that was a question we got in. And you'll see at the top, very simple stuff. Who's the patient? Who's the provider? The bottom, you have these 3 boxes. Those are the 3 questions. Please answer them. Number 3, temporary impairment percentage. That is the jargon way of saying degree of disability. Okay, I try not to use the jargon on these, but there you go. Degree of disability equals temporary impairment percentage. Now, you can and you frequently are supposed to upload your treatment notes. Great. So this is method number 1. You could indicate this information on our template. Method number 2 is you can indicate this in your treatment notes. That's fine. It's just that I'm asking you, would you please, in your treatment note templates, would you please add these 3 questions to make sure you don't miss them? Thank you very much. And I do say that as genuinely as I can, because I do appreciate the work that our providers do in caring for our injured workers. Now, there's a new topic under indemnity called the permanent partial disability. Let me explain to you how this works. Everyone who's injured on the job is going to be temporary at first unless the doctors determine that unfortunately this worker has a permanent injury, as in the worker's gotten as well as the worker's ever going to get. The worker has reached maximum medical improvement, known as MMI. And now we have to determine how injured is this person, because the rest of the indemnity benefit is going to be based on this amount. Well, it is possible that someone can be permanently and totally disabled, but it is more likely that the worker is going to have a permanent partial disability. Okay, we're going to do the partial first, and then we have something to say about total on the next slide topic. How disabled the worker is in the permanent partial realm is going to be determined, or we're going to use something to calculate the benefit known as the loss of wage earning capacity. You will see on our table on the left side of your screen, LWEC, LWEC. Everyone calls it LWEC. This calculation, the loss of wage earning capacity, maps over to a certain number of weeks of benefits payable for the worker. So at the top, if the worker has a 96 to 99% loss of wage earning capacity, they are one click below total. So number one, if you're a worker and this is you, I would encourage you to pay attention to the next slide. But that would equal 525 weeks of benefits. We did the math. That's 10 years. So you would get benefits for 10 years and then they would cease or stop. As you go down the scale on the loss of wage earning capacity, you'll see that the number of weeks declines. It goes all the way down to 1 to 15%, which is 225 weeks. Adam tells me that's roughly 4 years of benefits. So you could see that we're laughing because I did the math. But you can see that the range of benefits available are 4 years to 10 years of benefits when you're permanently partially disabled, and it's based on your loss of wage earning capacity. It's not a straight mapping of your degree of disability, okay? LWEC is a very complex formula. We do not cover it here. It's of little value for us to cover it because the judges and the attorneys all know how to do the formula. And the formula or the decision how much wage earning capacity someone lost will be the subject of hearings. We mentioned permanent partial disability. There is, during the period where the worker is receiving the permanent partial benefit, well, it is definitely possible that the worker's health could deteriorate. The worker could get less healthy, get worse. And that deterioration of health could put the worker to the point where the worker is now, 6 years later, permanently and totally disabled. It's going to be based on the medicals, but that does happen, and workers and attorneys, you can come back and pursue what is called reclassification. So you're seeking to show that the worker's health has declined to the point where the worker is now permanently and totally disabled. This does happen. It is awarded. The board will award a reclassification to permanent total. It's a very grim thing if somebody's now permanently totally disabled, but if the doctors believe this, you can pursue this reclassification. There's also another benefit that is dramatically underused in this system called total industrial disability. Total industrial disability, like permanent total, will get you the indemnity benefit for life. Total industrial disability is a little different than permanent total because total industrial disability takes into account some other factors, such as the worker's level of education, maybe the worker's age, maybe the worker's facility with English, maybe the worker's realistic ability to gain other employment. So, we are mentioning these two benefits just in case you've been permanent partial, or maybe you're coming up on classification as permanent partial. Maybe total industrial disability is right for you. We're just making you aware these benefits do exist. They're on the books. If you have an attorney, discuss it. If you don't have an attorney, maybe this is a good time to consider retaining. Here is another best practice with respect to indemnity. If you have a bank account, if you're a worker and you have a bank account, if you're a worker and you can get a bank account, if you're getting payments, would you please consider using direct deposit? Some of us fought pretty hard a few years ago at the start of the pandemic to make direct deposit a mandatory option for you. Because before 2020, it wasn't. It was just an optional option. Now it's mandatory. The payers must offer you direct deposit. And guess what? The payers are thrilled if you take direct deposit. We're thrilled if you take it. Your attorney's thrilled if you take it because it eliminates the late and missing checks. I don't know why you wouldn't go on direct deposit. Also, if you get paid in cash and you're a worker, that's fine. Cash is still legal tender. I'm just going to urge you to consider keeping records if you get paid in cash because you might need them, especially if you have a comp claim. So why don't you get yourself a notebook or open up an electronic file somewhere and make note of who paid you, how much did they pay you, when did they pay you, what did they pay you for doing? Because if you have a comp claim, you're going to have to demonstrate your earnings, remember? You now have records. Holy cow. That might be the thing you need. Also, would you please note exactly where you were working when you were injured? Now, if you go to an office every day, that's easy. But let's say you work construction. Let's say you're in a major city or a very rural area. You do construction. You go from job to job and you got hurt on one of those jobs. Please note the location, the address. Please know the address when you file the claim. Because it is possible in a construction scenario in particular, there could be 2, 3, 4 different insurance companies in the mix. One of them is covering you, but we need to know which one it is. And if you know your address, we can pull the building permit. And when we pull building permits, all of a sudden it's much clearer who the right insurance company is. So if you know your address, put it down. If you represent injured workers and this is a scenario that's coming across your desk, get the address, please, when you file. You will save months of hearings. This is now a major topic we're going to spend a little time on. This is called labor market attachment. What is labor market attachment? What is this thing Joe is talking about? Well, here it is. We're speaking now to workers who are temporarily disabled. This only pertains in the temporary disability world. And furthermore, workers who are less than 100% disabled. Okay, so you have a partial temporary disability. The nickname here is temp partial. There's temp total, there's temp partial. So Adam, if you're temp total, how disabled are you?
100.
100%. So now this is everyone who's less than 100% disabled. You may, it's not for sure, but you may be asked to demonstrate that you are looking for employment within your restrictions. And this will allow you to continue receiving your indemnity. This is coming out of what's known as case law. This is not specified in the workers' comp law proper. The workers' comp law itself doesn't say you have to do this, but the system is 109 years old. There have been enough cases that have been decided by the board and by the appellate court that this is now a thing. The insurer may raise this at a hearing, and the judge may direct the worker to demonstrate that the worker is seeking employment or that the worker is attached to the labor market. Okay, that's all the background. Workers, you are going to have to demonstrate a timely, diligent, and persistent work search. That's the criteria that is used in evaluating how well you did. Timely, diligent, persistent. You'll notice that there's no date, there's no number, there's nothing objective there. This is a subjective endeavor, but that's what we have. So you have to show that you are consistently, that would be diligently or persistently, that you're looking for work. The amount of effort is going to be determined at a hearing by a judge, or if it gets appealed, by a panel of board members. So, what do you do? Well, to demonstrate your labor market attachment, you're going to have to file documents with us regularly. How do you demonstrate it? Well, one avenue, there are a number of avenues, okay? You can use the resources we are showing you here on screen. Like, for example, New York State Department of Labor, they have reemployment services. You can take advantage of those. And then you would document that you're doing that. You can go to their one-stop career centers, the Department of Labor one-stop career centers. And you can do your searches there. You can search for work there. You can also follow up on any matches. You can take seminars, orientation, counseling. You can do this and you would document it. You can also become a full-time student of higher education or join a training program, a retraining program. If you have a high school diploma and you never went to college, maybe this is your opportunity to do that. Maybe you're going to enroll full-time in a 4-year institution or a 2-year institution or one of our great community colleges in this state. You fill out your FAFSA, you get your financial aid, you're a full-time student. You can use that to demonstrate that you're seeking employment. It's a proxy, but the judge will consider that and decide, yes, that does, or no, it doesn't, but you can do this. You can also take advantage of vocational rehabilitation via an entity known as Access VR. They used to be known as VESID if you've been around a while. All of these options you must document on, well, you could document them freestyle on a piece of paper, but you could do the easy thing and you could use board form C-258, which we are showing you on screen. You might be filing multiple copies of this, and that's fine. The point here is if you use these services, get them on form C-258 and include a resume. You need to include a resume as well. That's a very good idea, and you need to file this with us. Adam, what's the question we just got?
And you were just speaking to going back to school full-time. Someone asked, can we attend school part-time rather than full-time if full-time would be too overwhelming? They're just curious.
Yes, you certainly could. The judge is going to make a decision on whether that meets labor market attachment. I don't know if you want to couple that with a work search, but that is within the realm of possibility. Just remember, I'm not making the decisions. I'm not telling you, yeah, that definitely, or no, it definitely doesn't, because I don't make those decisions. The judges do. But, okay, that was a good question. Thank you. Now, you're welcome. Now there's another route to show that you would consider in trying to demonstrate your labor market attachment, and that is simply applying for jobs. Today, almost all, pardon me, almost all job applications and searches are done with the aid of the internet, online. Yes, we know everyone's pushing you to fill out an online job app, but that helps you workers because it makes it very easy to document all of these applications, because what you're doing is you're demonstrating that you're attached to the labor market. Well, to demonstrate it, number one, you need to do it. Number two, you need to show us you did it. So we have another form known as the 258.1, and you can use this form to document your work searches. If you get back something online from the party you applied to, you applied to Adam Rossi Technology Company, and the Adam Rossi Technology Company, they're great. They give you back an acknowledgement right away saying, thank you for applying for this job as a senior software engineer. Capture that and include it. Show us what you're doing. So on screen, we're saying, give us the details, please, the date, the name, phone, or address of who you contacted, the position. That's if you had like an interview, or if you just applied. Capture the application date, the position, the site name you used. If they had like a reference number, sometimes it's like job J1734, an internal thing to them. Put that in there. Show us that you're diligently working to find a job. If you get email confirmations, include them. You don't know, you might get a job out of it. But the point is, if you don't, please show us that you are. And then the question is always, how much do I have to do? Well, remember I said you have to demonstrate a persistent work search. So I can't give you a number of applications. I can just tell you, you should be demonstrating a persistent work search. And so I can give you the piece of advice that says, you're looking for work, treat it as a full-time job. Document everything on the 258.1, file multiple copies. If you were told on December 1st, you need to be searching for work, and your next hearing is February 28th, okay, that's December, January, February, that's 3 months. Maybe file one a week, but it's okay to file multiples. Why don't you go ahead and do it? Point is, whatever you're doing, document it and file it, please. All right, that's our discussion of labor market attachment. It is a very important thing. Please be diligent about it. Please be persistent, and please be timely, and include your resume. Send us your resume too. Now, new topic. You're getting payments. Everyone wonders if their payments are late or not. Well, here's how it goes. At the start of injury, the benefits should be flowing within 18 days of injury, or 10 days from when the employer and insurer got notice, whichever's later. Okay, so that means if you got hurt on November the 1st and you told your employer on November 2, and the employer told the insurer on November 2, 10 days from that is the 12th, but then we go to the 18 days from incident because it's later. So you got hurt on November 1, the benefits should start flowing by November 19. If that doesn't happen, there's going to be a penalty issued. The board does that automatically. And it's the workers, it's not your penalty, it's on the insurer. Now, what happens if there's a decision made by a judge? Well, let's say the judge said, okay, benefits should start and they should be $1,000 a week. That's at a hearing on November 1st. Well, it takes a day or two, or sometimes 3, to prepare the formal decision. It needs to be created, typed up, so to speak, etc. So it might take 2 days for that. So you look on the bottom right-hand side of your decision, it'll have a filing date. So November 1 was your hearing, November 3 is a likely filing date. The payment has to be released within 10 days of November 3 or November 13. If you're already enrolled in direct deposit, you're going to get it by November 13, probably before that. But if you're not, and the payer has to send you a check, now we're looking at the postmark. It's going to have to be postmarked by the 13th. So keep your envelopes, workers. If it's not, tell us. If it's not, tell us you might qualify for a penalty. Let's say you're getting ongoing payments. Every 2 weeks you're getting a payment. Well, if you're in direct deposit, you're probably going to get those payments every 2 weeks. Let's say you're getting checks. Okay, your check is 1 week late, 2 weeks late. I'm sorry about that. I really am. But it's not formally late until it's 25 days late. Another reason to get direct deposit. And also, if your claim is appealed and you didn't get a payment, but now the appeal said, nope, worker needs to get paid, doctors need to get paid, well, interest could be due. So if you're a payer, let's do those interest calculations and let's send that interest payment before we have to ask you to do it, because then that's a whole other thing. We're going to shift now to medical care. There is something known as the medical treatment guidelines. We have these medical treatment guidelines in this system that pertain to 16 different scenarios. There are 16 different individual medical treatment guidelines, and Adam has been kind enough to highlight them for you on screen. We are showing you the web page where we have all this information. So what we're saying here is that the treatment should be conforming to the medical treatment guidelines, and there are going to be instances where a treatment is authorized already under the guidelines. So if you're in a provider's office, go ahead and do your treatment. That's why we have a guideline. If the guideline says your treatment is authorized under this guideline, you can go ahead and do the treatment. However, sometimes the guidelines say that the provider is going to have to file for prior authorization. You may hear the word PAR, P-A-R. We're not playing golf. PAR stands for prior authorization request. Okay, how do you make a prior authorization request? You use a piece of software known as Onboard. I'm sorry if you don't wish to use Onboard, but you have to. So there are some circumstances when you're going to need a prior authorization, and here are the two big ones. Number one, the treatment the doctor wishes to do varies from the guidelines. That means you're going to need a variance because you're varying from the guidelines. And the second common instance of prior authorization is the treatment is going to cost more than $1,000. So this is a point in the system where we get loads and loads of inquiries, and there are loads and loads of moments of discussion, review, etc. So let's show you now what the review process is for these authorizations and variances. There are 3 possible levels. here's what'll happen. The doctor wants to do a surgery. The surgery is not automatically authorized under the guidelines, so you're going to need a variance because you're varying from the guidelines. So you go into onboard. Yes, you have to go into onboard, even if you're out of New York State. You don't use paper or make phone calls anymore, people. I'm serious. I still hear this from people. My doctor called the adjuster. No, the adjuster's not giving you a verbal okay. It's not happening. You have to go into onboard. You have to file what's known as a level 1 review. So you indicate why you're varying from the guidelines. If you are a medical provider, if you're just uploading treatment notes, that's not the most complete way to do this. You probably would benefit from writing something and indicating why you are varying from the guidelines. So now you've done that, and an adjuster, or more probably a nurse at the payer, is going to review. If you get a level 1 approval, okay, you're fine. Continue treatment. However, it is possible that the nurse at level 1 might deny this. Okay, that means that your request is now automatically escalated. You don't have to do anything. It's automatically escalated to an actual physician at the payer, level 2. And it certainly does happen that a physician with the increased training and knowledge says, no, I agree. This surgery is appropriate. So the physician at level 2 could approve. Great, go do your treatment. But it's also possible that the physician at level 2 denies again. Okay, if you're the treating provider, now you have a choice. You can either read the denials and see if there's something that you're missing that you could submit. And if yes, do that. It's perfectly all right to resubmit with additional information. You'll go back to level 1. But let's say that you submitted everything, you made your case, and that doctor at the carrier is denying, but you are confident in what you've submitted. You now have to escalate the denial to level 3. You have to go in onboard and take a step. And now it's coming to the medical director's office here at the board. We have medical staff. We have a medical director who is a really educated physician. I think he also has an MPH. But we do have a physician who's running the medical director's office. They review it, and they could approve it. So if they approve it at level 3, go ahead and do the surgery, continue treatment. If they don't, I'm going to urge you to read whatever they said carefully, because they will give you a lot of detail. They want to see the patient get treated too. They will give you a lot of detail. And if there's something you need to change, go ahead and change it, resubmit it, start level 1 again. This also pertains to the drug formulary, because we do have a drug formulary. It's come into play in the last 5 years, I think. It wasn't always the case. It's about 5 years old or less. And if it's authorized already per the formulary, you don't need to file anything. Just prescribe, and the pharmacy should be dispensing. If you're a payer and it's authorized in the formulary, if you get a drug request, if it's authorized in the formulary, I would not expect you to deny it. But let's say it's not already authorized in the formulary. Guess what? Same process. It's just that the documents in the system, instead of saying MG, they will say RX. Okay, MG for medical guidelines, RX because that's how we say prescription. I don't know why prescriptions are RX. I'm sure somebody will tell me in the comments. Okay, so that's a review of the process on medical treatment guidelines. Here's the best practice for medical care. I'm sure everyone in medical practices is going to applaud when I say this. Your worker, please show up at your appointments with your WCB case number. We're going to give you an 8-character case number. If it's a newish claim, it's probably starting with the letter G, as in gorgeous. If you're a volunteer firefighter or a volunteer ambulance driver, your claim is going to start with FA, and then you'll get 6 numbers. If it's another type of a claim, it'll be either 8 numbers or it'll be G and 7 numbers. I'm saying that specifically because the insurer is also going to give it a case number. This is the case number you'll see on your checks if you're getting checks. That case number will be dramatically different, and it varies by insurer. Everyone has their own structure. There are some insurers who have case numbers that are 15 numbers long. Well, show up at your doctor's appointment with our case number, the insurer's case number, and the name of the insurer. Give them a fighting chance to get paid here because they have to file their bills and their reports with both the board and with the insurer who's going to actually pay them. Now, on this topic, let's talk about independent medical exams. This is an element of the comp system. The insurer does have the right to ask the worker to attend an exam given by a doctor the insurer has hired, who's going to give an opinion on some element of your claim or your health. Such as, what's your opinion on the degree of disability here? Or, has this worker reached maximum medical improvement? Is this worker as well as this worker is ever going to get? Because if their doctor says, yes, this worker has reached MMI, well, now they're going to consider, do we want to move to classify the worker as permanent partial or permanent total? Okay, here's what you need to know if you're a worker. Number 1, this doctor's not treating you. This doctor's not giving you any recommendations on treatment or prescriptions or anything that you usually get at a doctor's appointment. That's because, number 2, there's no doctor-patient relationship here. All the privacy and protections that you enjoy at an appointment for treatment, they don't pertain here. So, what should you know? Well, number 1, you may bring a witness. You may. It's that simple. That right never went away even during COVID. Number 2, you may record this exam. Your witness can use a cell phone and capture the video and the audio of the appointment or the exam or both. I would certainly think you'd be interested in the exam because number 3, you are getting a copy of the report that the independent medical examiner, that doctor, is creating. You should review it. If there are findings and determinations and measurements in that report that you don't remember happening or that are not on the video as you see it, you should bring that to the attention of your attorney if you have one, because the attorneys aren't doctors, but they're a lot more knowledgeable than a regular layperson. They might recognize a test the doctor did that you're not recognizing as yielding that range of motion. But maybe they don't see it either. Or maybe you don't have an attorney and you still don't know where these findings are coming from. You bring it to the attention of my office. You also can bring to our attention, in the form of a complaint, anything about the IME conduct, as in, you should be seen in a medical office. You should be treated in a civil and respectful manner. We're talking about conduct now. If there is something about the conduct of these parties at the exam, these people, the staff, the doctor, or if there's something about the facility or anything else that is off, you can make a complaint to my office. When I will get the complaint myself, I will look at it, and I will almost certainly pass it on to the practice committee. We have an internal committee that we call the practice committee. They'll review it. And we're talking about people from the medical director's office who know what should happen at an exam. We have some lawyers involved too who know the legal rules, and they will investigate it. And yes, they do make inquiries with IMEs, with the doctors. They do make inquiries with the IME company who hired this. And it's within the last 2 years that an IME company actually lost its license because they had so many egregious failures. So you can make that complaint about conduct to my office. If you don't like the findings, if your doctor says you're 100% disabled and this doctor says you're not disabled at all, you're going to have to litigate that. You're going to have to go to a hearing and litigate that because that's not conduct, that's a finding, different. Finally, don't forget, you can claim travel reimbursement. Use Form C-257 and submit that for reimbursement for your mileage or your transportation expenses to and from this appointment. And this is a moment where I can speak to the insurance people on the call here. Can you please make it a practice to get the worker to the closest likely IME? The closest one, please? Because sometimes workers are asked to travel great distances when maybe somebody's closer. So that's just a little from me to you. New topic. We're getting to the end here, folks, and then we'll do your questions. But appeals. Well, we're going to save that question. Okay, appeals. We'll get to your questions afterwards, okay? But let's talk about appeals for a moment because this is possible. This does happen about 14,000 times a year in the comp system. That's a real number, by the way. I don't just make numbers up here. It is possible that a judge's decision could be appealed. Either the worker can appeal it or the payer can appeal it. Remember I mentioned the filing date of your decision? It's in the lower right-hand corner. The hearing was November 1, filing date November 3. Well, the parties have 30 days from the filing date to appeal. If you're a worker and you want to appeal it, you have 30 days. If you're a little late, you might get some slack because you're a worker. If you're a payer, you are probably not getting that slack because you're an insurance professional. But my point here is that if you're a worker and you have an attorney, your attorney's doing this, okay? Defer to your attorneys, please. Or rather than defer, I should say, talk to your attorneys, understand their point of view. They're trying to help you. But let's say the thing is appealed and it comes in 30 days. So November 3rd is the filing. Let's say you're a worker and the payer appeals it and the appeal comes in on December 2. Because the payers do tend to file their appeals on day 29 and day 30. Okay, so it's here on December 2. That means now you have 30 days to rebut it. Now, what you need to know if you're a worker, if the judge awarded you money and the payer appealed it, they get an automatic stay on payments. So they're not going to be paying you during this period of appeal. That's why on the worker side, you and particularly your attorneys tend to file quicker than 30 days because you're not getting paid. So let's say your appeal comes in, your rebuttal comes in on December 20. Okay, now we have the full appeal. Now it's going to move to a panel of 3 board members. We didn't explain this to you, but here you go. There is actually a workers' compensation board of 13 people. They were nominated by the governor and they were approved by the state senate. The chair of the agency is the chair of the workers' comp board. So she chairs those 13 people, and she's also the head of the agency itself. So these 3 board members are now going to consider your appeal, and they're going to make a decision. Let's say they uphold the judge's finding and your due benefits. The insurer will release the money now because they have to. However, this might not be the end, because once the panel members make their decision, either party, the losing party obviously, can appeal it again. They can appeal it to the full board of 13 people to ask for another try. Now, what's going to happen is, if the 3 panel members split 2-1, it's going to definitely go to the full board. That is what's called a mandatory. All right, so now the full board is going to pick it up and consider the application, and you're going to have the opportunity to write another response, another pleading. But it's also possible that the 3 panel members all agreed. Well, if one of the parties wishes to appeal that, that's now called discretionary, which means the full board has it within its discretion to accept your appeal or not. From there, after the full board, either party may leave the comp board and appeal to the New York State Supreme Court, Appellate Division, 3rd Department. Or it is technically possible that after the 3 panel members decide, bullet number 2, you could skip full board and go directly to the New York State Supreme Court if it was a discretionary appeal. You don't even have to do that. You can go directly to the appellate. It's unusual, but it's possible. But it's unusual because you have to pay a fee at the appellate division, and you don't pay a fee for a full board. So typically, parties will go that route. But you can go to the appellate division directly. Either way, the important point here is you have now left the board once you're at the appellate division. So we can't help you at that point. You're out of the board now. Okay, so that's how appeals go. And it is technically possible to go past the appeal. New topic, we're almost at the end, but this is a big one. This is a bit of an aside from me, giving you some education that workers need. What's a settlement? One of the primary reasons I cover this is because I hear workers using the term settlement very casually, very imprecisely. A settlement in our system is known as a Section 32 waiver agreement. This is the only time you should be using the word settlement. Please don't call payment from the insurer a settlement unless it's a Section 32 waiver agreement. What is that? Well, that means you are closing part of your claim, or you are totally closing your claim. Let's show the little video thing. Okay, we have a little video on this. I'm very fond of it because I wrote it. That's an ad. Sorry about that. Okay, here you go. This is the video. It's only 6 minutes, and you need to look at this video if you're thinking of closing your claim with a Section 32 waiver. And what this means is the following. You have decided, you and your payer, you did this together, okay? You negotiated a true settlement. You're going to close the medical part of the claim, you're going to close the indemnity part of the claim, or you're going to close them both. And the claim is going to close upon signing. I think there's a 10-day cooling off period, and then it's truly effective. And you're going to get a payment, and that's it. You have now left the comp system for that. Let's say you close both the medical and the indemnity. You're going to get a sum of money that's going to represent your indemnity. You can spend that now. You're going to get a sum of money that's going to represent your medical care expenses for the rest of your life. You're going to have to put that in a special account. You cannot spend it on a Corvette. You have to keep it and spend it on medical care only. Sorry, that's just how it goes. But the point is, you have now left the comp system. You can't come back for more. You can't come back in a year and ask us to reopen it because it is permanent. That's why I say, please don't use the word settlement unless you're talking about a Section 32 waiver agreement. It's entirely optional. We cannot compel an insurer to enter into one of these with you because it's entirely optional. And also, the board does not get involved in the negotiations. All we do is we get a copy of it. One of our judges will review it, and it's only going to be rejected if it has errors in it. I'm talking about legal errors, or if it is unconscionable. Other than that, this is entirely optional between workers and payers. It's also the kind of thing that you might benefit from an attorney's counsel on. How do you find an attorney? Well, we can't give you the name of a particular attorney who we think is really good. Sorry, we can't do that. However, here are some resources you have. Number one, New York State Bar Association will give you a list of attorney names. There's the contact info. There's an association of a group of attorneys in New York who tend to represent injured workers. It's called, surprise, the Injured Workers Bar Association. You can contact them. They will give you a list of names. You can also use a licensed representative. These are people who passed an exam that the board gave. It's a pretty rigorous exam, and they passed it, and now they are licensed to represent workers. You can get their names off of our website. And then finally, if you have a medical-only claim, as in you don't get indemnity payments, you've never gotten indemnity payments, but it's still an injury that is requiring medical care, and you need the help of an attorney because maybe there are hearings on medical treatment guidelines or whether you could get a treatment or not, you're going to have a hearing. That does happen. We have hearings even in medical-only claims. If you can't find an attorney through one of these other ways to represent you, visit the New York State Bar Association, and on the left side of the page, you'll see workers' comp. Select that. We have a program with the Bar Association that we created wherein they will give you a referral to an attorney who has agreed to represent you pro bono in this medical-only claim. Really recommend you check that one out. All right, our final topic before we go to questions, virtual hearings. Here's the thing. You might have a hearing. We are still not doing hearings in person. We're going to reopen. I can't tell you when because I don't know. It's a governor's call. But we are going to reopen at some point, and you could come in for the hearing in person, or you could continue to use the virtual hearings. We have this thing in place where we can do the hearings remotely, and it's the reason why we didn't lose any hearings in the pandemic. Unified court system closed down for a while. We didn't. So we're bringing this to your attention because if you have a hearing today, you're going to get a hearing notice, and it's going to say you can attend by virtual hearing or you can attend by phone. Virtual hearing, we have an app that actually works quite well. You can get it from Google or Apple, download it, and you can do your hearing that way because it's essentially a teleconference. You need a camera, you need a microphone, and you can do your hearing that way. You can also look at your hearing notice and it will show you a web URL, a website you can go to, put in a code. You could do your virtual hearing that way. Or your hearing notice is going to say you can phone into the hearing. And I'm calling this out to you because there's a little confusion out in the public about this. If you want to participate by phone, okay, that's all right. That's fine. You need to tell us before the hearing that you're going to go by phone because the judge calls you. The judge calls you. You don't call in. Your lawyer doesn't call you. The judge calls you. So you need to tell us before the hearing you're going to use the phone, and you need to give us the phone number the judge can use to reach you. This is all on your hearing notice. Okay, we're getting towards questions. So here are our social media presences. We don't just announce trivial stuff. So you can follow us on these social media sites. YouTube, you see that YouTube address? I'm calling that one out for you because we have literally hundreds of videos available on our YouTube, including like the recordings of these sessions. This webinar will be on YouTube in the near future. Adam's really good about that. The last one, you can sign up to get notifications from the board. You can pick the categories you like. We announce these things via those notifications, just calling that out. And then finally, we're going to leave this slide up. Here's how you reach my office. So please make note. Let us hear from you if you need us. Now I'm going to throw it back to Adam.
All right. Thank you, Joe. It is now time to take your questions. Again, if you have a question, feel free to pop it in the chat box on the bottom right-hand side of your screen. If you can't find it, there's a little chat bubble icon. Just click on that. It should pop right up. We do have some questions that have already come in. I know Joe answered a couple during the presentation, but we also had a few others that we did not get to. So we are going to take a moment to go through the questions that have already come in. We will be back with you shortly. But again, if you have a question, feel free to type it in and we will do our best to answer it. Thank you. All right, we are back. Thank you guys for giving us a moment here. So our first question, provider has been treating a patient that has newly established workers' comp injury. The patient's claim became controverted. The patient never showed up to the hearing, so the judge ruled in favor of the carrier. The patient wound up moving out of the area and has not followed up on the claim with the provider, and they are not working with an attorney. Can that provider bill the patient?
Yes. If you have private health insurance info for that patient, you could start there if you like. But yeah, if the claim is disallowed, you're describing a situation where the claim was disallowed. So yeah, you can move forward with other payment methods.
All right, so next question here. If the claimant sends us work searches on something other than a board form, are we submitting these on the subject line electronically as ATTYCOLR, which I'm assuming it's attorney something, but they are having trouble getting the board to scan HIPAA requested by an administrative law judge?
Okay, I can clarify for everyone who's not familiar with the lingo here.
Attorney correspondence.
Not just you, Adam. All right. So let's say the worker is sending the worker's attorney. I'm going to presume this is the attorney writing the work searches. Great. Step one is working well. Now the attorney needs to get them in the board file. Okay, whether they're on a board form or not, you need to get them in the board file. So you can always put them in the US mail. That's your ultimate fallback. But you want to submit them electronically because it's faster, easier, great. You're going to be sending them to WCB claims filing at wcb.ny.gov. By the way, yes, Adam's going to give you that address right in the comments. WCB claims filing at wcb.ny.gov. That is the email address you use to submit documents to a claim folder. And the key here, counselor, is in the subject line, you put the case number. If you want to include attorney core, feel free. We will, we might put attorney core as the heading internally, or we might just put core. But either way, the point is you need the case number in the subject line. Let's get them in the right case. Here, I'll go a step further. I understand what the counselor is trying to do. He or she is trying to call these out in the file, which is a good idea. If it turns out you get a volume of these in the file and you wish to call them out specifically, tell us. Tell my office, okay? Email my office and tell us that there's this volume in the claim folder that you want to call out as work searches. If they're not already labeled as work searches, tell us, we can label them.
All right, next question. So what happens if a claimant is told at a hearing that they need to demonstrate labor market attachment within 60 days because the disability is less than 100%, but then the medical provider sends in new medical documents through e-case stating 100% disability within those 60 days? Does the claimant still have to demonstrate the LMA?
Potentially yes, potentially no. If you see, now you're getting very far in the weeds, but that's okay. Let's say that there's an IME that says 50%, and now the treating's coming back at 100. Well, we still have the controversy between the 50 and the 100. So the fact that the treating went to 100 doesn't automatically obviate the IME opinion. We all know that. We all know that gets litigated. But if it was just the treating opinion that went to 75 or 50 and now the treating's at 100, if the judge said you have to demonstrate and now there's this 100%, well, there's probably going to be another hearing, so you would have to make an argument at that hearing that you shouldn't be demonstrating. In essence, I cannot make this call for you because I'm not a judge. This is all within the judge's purview. Okay, so just be aware of these potential moments in the system. You might still have to demonstrate. It's going to be up to the judge to say no.
If an employee misses less than a week of work, do they receive payment?
Great question. Okay, this is a foundational question we do in the 101, but here you go. There's a specific little timeline for indemnity in our state, and here's how it goes. If a worker misses 1 to 7 days, there's no, well, before I even say that, I'm sorry to catch myself. Let's assume there's no collective bargaining agreement. Okay, let's assume there's no collective bargaining agreement. Because collective bargaining agreement could have different terms in it. But here's the general law. 1 to 7 days, no, there's no indemnity. 8 to 14 days, yes, should be paid for days 8 to 14. 15 days or more, we go back to day one and you should be paid from day one. Okay? So that's really how that goes.
How many therapy visits are claimants allowed to have how many therapy visits for the claimants is allowed to have the prior provided request authorization?
All right, how many therapy visits can patients get before the provider has to request authorization? That's what they're getting at. Okay, number one, we're going to assume, well, no, we're not going to assume. Here's how it goes. The easier one is when you say therapy, are you talking psychological therapy? Because if it's psychological therapy, you're going to need to have a psych illness established on the claim. And then there are some psych guidelines you might have to conform to. If you're speaking about physical therapy, occupational therapy, well, the rule is if it's maintenance therapy, you can have 10 per calendar year. If it's not maintenance therapy, you should be requesting the prior authorization from the get-go. Okay.
All right, so when you receive a proposed conciliation decision from Form C 8.1 in disputed medical bills, who files the objection, the claimant or the provider?
Oh, okay. This is a very interesting point in our system. If there's a disputed medical bill, there's going to be a decision made from Form C 8.1. So we're going to make a decision. It's going to be what's called a proposed decision, and it's going to go out to the parties, even though it is impacting the provider, as in whether the provider is getting paid or not. It's a little quirk in our system that the provider doesn't actually have the right to object to it. Yes. And by the way, this is something that is known within this agency, and it is something that people such as myself are very interested in. Why doesn't the provider have standing? But the provider doesn't. So the objection would have to come from the patient, the worker, the claimant. So providers, feel free to talk to your patients about this.
All right, so when a worker applies for short-term disability during a claims dispute, and if the claim is resolved in favor of the worker, is the carrier then required to repay the disability funds on the amounts collected?
This is another excellent question. And I have to apologize because I did not close this loop when I was talking about the short-term disability claim. So sorry, team. I need to close the loop by saying, let's say you went for the short-term disability benefit during the period of controversy. Now the claim's either going to be allowed or disallowed. If the claim is disallowed, that means you don't have a payable comp claim, you're keeping the disability payment. Let's say the claim is allowed and established. Okay, now you have a payable comp claim. The two insurance companies, the comp insurance company and the short-term disability insurance company, they might be different insurance companies. Don't worry about it, workers. The two of them will talk to each other. They will exchange funds as necessary. The whole thing will be transparent to you.
All right, next question. What happens when a worker uses all their medical allotment? Can they retreat under their private insurance or for the settled injury?
All right, we're going to expand upon your question a little bit so that it's clearer to everyone. I think I know what you're asking, but I'm going to rephrase it a little bit. What happens if a worker took a Section 32 settlement, remember the one and only settlement in our system, and the worker settled medical care, and the worker got a sum of money, and the worker has spent all that money on medical care. But the worker is still alive, and the worker needs more treatment. That's up to you. You have left the comp system. I can't tell you how to get that paid for because you are now out of the comp system. Therefore, the only thing I can tell you is if you're ever going to take a settlement for your medical care, please think about how you're going to pay for that medical care if and when you exhaust those funds. Yeah, go ahead.
So on the topic of Section 32 agreements, even though benefits are discontinued due to the agreement settlement, can the claimant still receive vocational rehab services through the board?
I have to tell you, I'm not certain. You should certainly reach out to Voc Rehab and ask them for help. I'm just not certain of what their internal procedure is. I might advocate for you to get it, but that's what I'm going to find out after the session is over.
All right, so we did have a few more questions come in. Sorry about that. So our next question here. My doctor did not rate my disability. So am I considered 100% disabled for the last 3 months that I'm off work?
Absolutely not. Go back to your doctor, get the degree of disability. Nobody's assuming that you're 100%. If there's no medical in the file, go back to the doctor, get it filed, contact the adjuster about restarting. If the adjuster doesn't, contact my office, we'll review, and based on your premises, the benefit should be restarted, based on these premises, of course. And if the adjuster doesn't restart, contact my office, we'll review, and if appropriate, we'll contact the adjuster for you. Okay, go ahead.
Okay. When an MTG variance par is escalated to level 3, instead of having to input into the text box, can the system be adjusted to download a document?
Okay, our questioner is asking a very technical onboard question. All right, so this person's asking for an enhancement. Okay, you should pose that to onboard. Okay, I could go to them with one thing, or you can pose a suggested improvement to the onboard staff. Adam, how does our questioner reach them?
You can email either. Well, what I would suggest is, so we do have an onboard mailbox, but it is not monitored unless there are certain things we look for. But you can always email onboard@wcb.ny.gov. But I would also encourage you to CC the MDO mailbox, which is mdo@wcb.ny.gov. I am typing this out right now to put in the chat box, so bear with me 1 minute. But yeah, so you can email that onboard mailbox, but CC MDO in there as well, and then they can also take a look at it and take your suggestion.
Oh, really do it. Yes, so go on ahead and do that. We are open to improvement, people. We are open to suggestions such as that. If there's anything that we could do to onboard to make it easier to use, tell us, please, because we absolutely do go through these and absolutely do talk about them. Yeah.
All right, so why do you have to provide a copy of your resume when you submit a record of job searches?
The obvious reason is it indicates that you are taking this seriously. It's not going to be done. It's not timely. It's not persistent. We'll consider it diligent. I'm just giving you a tip. There's a reason I'm saying this. Yeah, submit a copy of your resume because it might help demonstrate that you're diligent about the whole thing.
All right, so we have a questioner here. While they were temporarily disabled or noted as temporary disabled, the insurer offered them money to resign, and they are a little confused by this. They are not represented by an attorney, and they're just looking for some guidance.
This is a very interesting scenario. You're sure the insurance company offered you money to resign? Do you have that in writing? Did you get that on a phone call? We're going to need some details on this one. It's unusual in my experience that an insurance company would offer you money to resign, unless you're saying that you're negotiating a Section 32, and one of the conditions would be your resignation that you want to bring forward to the board. We did make an announcement recently, I believe, about resignations in Section 32s. I don't think that we look favorably upon those. So you need to bring that to our attention. What else do we have? What else do we have, Adam? Can a provider refuse to treat if treatment is authorized without prejudice? That's an interesting one. Providers do have health law that they have to conform to, number one. Number two, if if they're refusing to move forward with a treatment because it's authorized without prejudice, well, is it an authorized provider? If it's an authorized provider, which you should be using and which you very possibly might be, you need to bring that to the attention of the medical director's office. Adam has just given you their email address. Thank you. Use it. Write the details and send it to the medical director's office, and we will contact them and discuss this with that provider.
When a payer refuses or stops paying medical bills, can workers be billed?
When a payer refuses or stops paying medical, okay, well, you have to go down a level. What's the reason? What's the reason why? Was the reason because the claim was disallowed? It's not a comp claim? Then, yeah, you're going to have to find some other way to bill. If they're not paying because there's a dispute in the claim, well, we need to resolve the dispute. But let's say that all conditions indicate that the doctor should be paid, all conditions, and the payer is still refusing to pay or is still not paying, well, the remedy there, providers, is you file a judgment. You can file a judgment against that payer. And maybe you want to make them aware that you're pursuing judgment. That might be the thing to do. Access VR, are the services free? I'm not sure. I think they are, but I'm not sure. I'm sorry, people. I need to find that one out too. I have a couple of vocational rehab assignments here. I think they're free. I'm just not totally certain. I'm sure if you ask them, they'll tell you.
If some patients state that even if they have a settled, they get medical for life, would that be different from a Section 32 agreement?
Well, the patients might be telling you that they settled their indemnity, but they kept the medical open. That's the question you ought to be asking. If you're clearly writing from a provider's office, just contact us. Contact my office via the email or the phone. We'll look at the file. We'll let you know. There are some occupational health clinics in particular that we work closely with doing just that service. So there you go.
Is there a time limit for filing a consequential injury?
No, because this is a concept that we should state as long as we're here. Let's say your claim's established for one injury, and then as time goes on, you suffer a consequential injury, which means your initial injury has created another problem for you as a consequence. No, there's no time limit for that. What you're really doing is you're adding an additional body site or an additional condition to an existing claim. That's okay.
All right, so we have one more question here we're going to take. Can you take a workers' comp claim to small claims court?
What would you take to small claims court? That would be the question. I don't know what you're taking to small claims court. So that one, they're not paying. Who's not paying? Is this a insurer not paying provider question? Okay. I don't know if you're a provider, if you can go to small claims court. I truly don't know the answer to that. I do know that within the comp system, we do have these other remedies. And Adam, it looks like somebody is pointing out to us, Access VR is part of this New York State Education Department. Yes, of course it is. I'm overlooking that, so I don't think they're probably charging you.
All right, that is all the questions we have today, so we are going to go ahead and wrap up. Thank you all for joining us. Thank you again to Joe for these great presentations that we do. We do our Workers' Comp 101 monthly. Just a reminder, if you want to join us for one of those. And these 202s we do also do sporadically, so just make sure you are keeping an eye out for when the next one is listed. We just a reminder, you can sign up to receive news on workers' comp, including future webinars, by signing up for email notifications. Just visit our website at the bottom of the screen. Or I'm sorry, go
Hold
to
the phone.
what?
Hold the phone.
Oh.
Just breaking in because we had one question that has an easy answer. Sorry, Adam.
No, you're good.
All right. So to our friend AD, do we have an attorney who'll take a case to get a doctor paid? You might be talking about a medical only claim. So if you don't have an attorney, remember, you can go to the New York State Bar Association, nysba.org. Put in workers' comp, look on the left. You can find a pro bono attorney who can help with this. Thank you for indulging me. As long as I'm here, happy holidays.
Happy holidays to everybody. And again, make sure you are following us on our social media pages, Facebook, Twitter, Instagram, YouTube. This recording will be updated on our YouTube page and our website. Again, make sure you sign up for email notifications so you are aware when that is available. And again, thank you all for joining us. Enjoy the rest of your day and enjoy your holidays and Happy New Year as well.